Friends, today is our 205th Friday group meeting. The topic is 75 years of Constitution and Supreme Court, part 2. Even last Friday we have a part 1. The speaker is our beloved senior advocate, Mr. Shekhar Naphade. So, sir, last time we could not complete entire this thing. I don't think then today also we will. So continuing this because there's a long journey of 74 years of our Supreme Court. Sir is kind enough to give this lecture with his energy and with his intellectual potentiality and all. Sir, now you can please, sir.
Now we'll begin today with Article 12. Now, if you look at the wording of Article 12, this is how it reads. In this part, that is Part 3, Fundamental Rights, unless the context otherwise requires, the state includes government, parliament, government and the legislature of each state and all local or other authorities within the territory of India or under the control of Government of India. Now, the debate started with reference to the expression other authorities, and this debate has a very interesting history. The first view of the Supreme Court was that a government company where more than 50% shares are held by the government, either state government or central government, or both the governments together, would not be an authority. So the court started with a bit conservative approach. In 1975, there is a turning point. That is Sukhdev Singh's case, where their lordships were called upon to decide whether oil and natural gas corporation, life insurance corporation and other corporations, which were statutory corporations, whether statutory corporations are other authorities within the meaning of Article 12. Because a company or a statutory corporation has an independent personality. If you see all these statutory corporation laws, you will find that they are constituted into a person. So they can be sued in that name and they can sue in that name. Similarly, once a company is registered, irrespective of how many shares are held by the government, it has a distinct corporate personality. So the initial approach of the court was that they have a distinct corporate personality and therefore they are not government and therefore they are not a state within the meaning of Article 12. Why this is significant? Because the courts have evolved way back in 1950 itself, or much earlier, the concept of administrative review of administrative actions. So whether any action taken by a government company or a statutory corporation, is it subject to the court's power of judicial review? That is how the debate starts. If it is not an authority, then of course the question of judicial review will not. So as I said, that the initial approach was conservative. They said no, they have a distinct corporate personality. They followed in letter and spirit the Solomon versus Solomon, which all of us learned when we started learning company law. That the company, once registered, incorporated, has a distinct personality, distinct from the shareholder. So that line of reasoning persuaded the court to say that they are not under authority. As I said, 75 is the landmark. Sukhdev Singh's case, AIR 1975 Supreme Court. But there the test which is laid down is very interesting. They said it's all right, they are statutory corporations. But the further requirement is, if they have a rule making power or a regulation making power under the act by which they are constituted, then this rule making or a regulation making is an indication that they are other authorities. So that was the test. The test was a statutory corporation having an authority to make a rule or a regulation which has the force of law. So a significant departure made from the earlier approach. Then comes 1981, Ajay Hasia's case, which holds the field even today. Now their lordships are, without any exception, have consistently held that where a government has a pervasive control, all pervasive control over the functioning of an organization, it is a state. Irrespective of whether it's a company, whether it's a society registered under Societies Registration Act or under any society under any state law. So, right from 50 to 81, 31 years, the court has shifted from a very conservative approach to a more progressive approach, if I may put it, that every action of a state, whether in the form of government order, law made by parliament or state legislature, or by statutory corporation, or a government company, or a society which is under a pervasive control of the government, is a state. And therefore their all actions are subject to judicial review. This is a very significant development. So Ajay Hasia and Sukhdev are landmarks. Now, I wish to bring to your notice that Supreme Court's interpretation of the Constitution or its application to given factual matrix has made a huge impact on our legal structure, legal system. There is no aspect of our system which has not received some kind of impact of Supreme Court's interpretation of the Constitution. I am not talking about interpretation of statutory provisions. I am talking about Supreme Court's interpretation of the Constitution while considering a given factual matrix, which has made a great impact on all aspects of our legal system. I will give you a few instances. Take for example education. If you read the relevant provisions of the Constitution relating to education, you will only find in the list 3. That is the concurrent list of the 7th schedule. Beyond that, you won't find anything. But in Unnikrishnan's case, 1993, a revolutionary step was taken by the Supreme Court. Why do I say revolutionary? Because in the first place it says that every child has a fundamental right to education up to the age of 14. That is the primary education. Now where do you get it? In express terms? No. But they read it into Article 14 and 21. So point 1. They don't stop at that. They also deal with the higher education. Especially by the time Unnikrishnan came to be decided, there were a number of malpractices in medical colleges, engineering colleges, their method of admissions, etc., the court had to step in. The professional bodies like Medical Council of India, etc., were not in a position to plug these malpractices. The court stepped in. There are 5 important propositions which the court has laid down in Unnikrishna's case. Number 1, as I said, right to education up to the age of the fundamental right, which ultimately is now transformed into Article 21A. So Article 21A's precursor is Unnikrishnan. The second important proposition laid down by the Supreme Court in Unnikrishnan's case was that in these professional colleges, 50% seats should be free and they should be available for nominees of the government and university or public authority. And remaining 50%, the paid fees, the paid seats. Now, whether free or paid, the admissions will be strictly regulated in accordance with merit, and for the purpose of merit, you will have a common entrance test. Now, this concept of common entrance test, which is now the rule of the day, goes back to Unnikrishnan. The third thing which the court laid down, that there has to be some mechanism to regulate the fees. The practice of capitation was rampant, and there were very few states like Maharashtra which had enacted laws prohibiting capitation fees. Across the country, all states had not adopted. Initially, if you remember, education was not in the concurrent list, it was in the state list, except a few items like Aligarh Muslim University, etc., which were central universities. The rest were in the state list. So the next was that there has to be some mechanism to regulate the fees. Now, Unnikrishnan is upset to some extent by TMA Pi. But before I come to TMA Pi, let me tell you the fifth important proposition which is laid down in Unnikrishnan. One, we saw 50% seats free, 50% paid, which is upset now by TMA Pi. Right to education up to the age of 14, a fundamental right, second proposition. Third, there must be a mechanism to regulate the fees. But the most important proposition, which I consider as a revolutionary measure, it's a constitution-based judgment. Now, their lordships say that Article 21 has two components. One is the negative component, with which we are all familiar, that no person shall be deprived of his life and liberty except by procedure established by law, which came up for interpretation in A.K. Gopalan, subsequently in Maneka Gandhi's case. Now, what is the positive component in Article 21? If you go strictly by the text of the statute, it's only negative in its format. But their lordships have read into that concept of liberty positive rights. So the question arose, what is the test that you apply to find out from Article 21 the rights which are not enumerated in the Part 3? Otherwise, in Part 3 you have several rights which are enumerated specifically. Right to move throughout the territory of India, freedom of speech, freedom of association, etc. But there are unenumerated rights which the court has read into the wording of Article 21, and more particularly the expression liberty. Now, how do you find out? What are those rights in that expression liberty? Their lordships have laid down an important test. They said, look at part 4. Look at part 4, which deals with directive principles of the state policy. So, Article 21 has to be read with reference to the part 4, which contains a catalogue of directive principles of the state policy. Now, what is the test that we have applied now? That any law or any mandate of any statutory provision has to be seen always in the context of part 4. And that is how, in Unnikrishnan's case, their lordships have read into Article 21 some parts of directive principles of the state policy. Now, this, according to me, was a very dynamic interpretation of the Constitution. Now, subsequently, number of judgments. Initially, we used to think, prior to Unnikrishnan, that if a provision of any statute is challenged, then in order to decide the reasonableness of the statute, we used to look into the part 4. That whether the impugned statute advances the principles that are laid down in part 4, then to that extent the restrictions put on your fundamental rights can be characterized as reasonable. But Unnikrishnan goes a step beyond. Now, what is the change which is brought about by TMA Pi? The TMA Pi does not overrule Unnikrishnan totally. It overrules only with regard to this 50% free seats and 50% paid seats. This is another aspect which is important in TMA Pi. But before I go to TMA Pi, whether anybody has any private institution has a right to charge capitation fees. This question arose first in Mohini Jan's case. Now, as I said, except a few states like Maharashtra, there were no laws enacted by the states or by the central government prohibiting the capitation fees. Now, in these days, we have a very euphemistic name, donations. They are nothing but capitation fees. That's a way of avoiding. But we are all anxious to see that our child gets into the best school or best college, so we don't mind being partners in crime. It was Mohini Jain's case, 1992, which said that there can't be capitation fees, which was affirmed in Unnikrishnan, which is affirmed even in TMA Pi. The one more dimension from TMA Pi is, it says that the right to establish an educational institution and right to manage is also a fundamental right. The question had arisen, under which article? If you see Article 19(1)G, it takes into several things, vocation, avocation, etc. They said it falls into that. But they don't say that running an educational institution is a business. That proposition is not accepted. The ban on capitation fees is affirmed, which was laid down in Mohini Jain's case and also in Unnikrishnan's case and confirmed in TMA Pi. So all that their lordship said was that a right to establish education institution and manage them is a fundamental right, and therefore any restriction that you put on such a right must be reasonable. There also their lordships have affirmed that there can be a difference between the fees that are charged in government colleges and government institutions and the private institutions. Their lordships have said that in order to maintain very high standards of education, these private institutions can be allowed to charge much higher fees than that are charged by government institutions. So these are some of the important. But as far as admissions are concerned, whether private, public, government or otherwise, they all must be subject to the common entrance test, must again be subject to the merit alone. So this is the impact on education. There are a number of other things. It's not possible for us to go into all that. Now let's see the impact of Supreme Court's interpretation of Constitution on some aspects of criminal law. We dealt with Gopalan's case in a different context. Now we deal with Article 20, Clause 3. That a person who is accused of an offence cannot be compelled to give evidence against himself. Now this expression first came up for consideration in Balsara's case, 1950-51. There the question was, this was under the Bombay Prohibition Law, where drinking liquor in Bombay was an offence. It was drinking liquor or possessing liquor or selling liquor was an offence under the Bombay Prohibition Act 1949. Now this Balsara was arrested for having consumed the liquor and his blood sample was taken. Now the question before the court was whether a person being required to give his blood sample, is he giving evidence against himself? Whether is he incriminating himself? The court said no. Now Balsara's case stands even today, but there are some changes which I will indicate to you. The second, voice sample. Whether an accused, suppose now his conversation is recorded on tape record or some other mechanism which are now available. Now how do you relate that voice which is recorded on any recording mechanism with that of the accused? Whether accused can be compelled to give voice sample. This also Supreme Court has said permissible. His handwriting, whether he can be compelled, Supreme Court said yes. So blood test, voice sample, signature, handwriting, etc. But then comes the Selvi's case, the narco analysis. In narco analysis, Selvi's case, the court has struck down that. Now, how do we distinguish all these cases, Balsara's case, voice sample case, handwriting case? The distinction which the court has drawn is like this. They have read Article 20, Clause 3 with Article 21. Now, in a narco test, some chemical is inserted by an injection in his body, and then questions are asked to him, and those answers are recorded. Now, because of that chemical in his body, his capacity to give conscious answers is impaired. Not only that, he gives an answer orally, it is giving evidence. In a blood, this, etc., he is not giving an answer. This is the distinction which court has drawn, and therefore it is self-incrimination and therefore hit by Article 20, Clause 3. Otherwise, if you superficially read Balsara's judgment and Selvi's judgment, you find that the court is contradicting itself. No, court is not contradicting. It is a well-reasoned judgment in Selvi's case, why they struck down. But before Selvi's case, there is an important case which I must discuss with you, and that is Nandini Saptapadhi's case, 1978. Selvi is 2010, Balsara is 51. Now in Nandini Saptapadi's case, the question arose. It's again a constitutional bench judgment. By and large, I am dealing only with constitutional bench judgment because they are landmarks. In Nandini Saptapadi's case, the question arose is with reference to two important statutory provisions and Article 23, that is 20 clause 3. One is Section 161 CRPC and the other is Section 179 IPC. Now, impact of Article 20 clause 3 on these two statutory provisions was the issue before the court. The first proposition which the court has laid down is this, that being compelled to give evidence against himself is not restricted only to giving evidence in the court. It is also extended to the stage of investigation. So, a police officer who has the right to examine any person, including an accused under Section 161 CRPC. Now, if an answer to the question put by the police officer to the accused, if has a tendency to incriminate him, whether he has a right, constitutional right to refuse to answer. In other words, right to maintain silence. Now, it has twofold implications. First is whether the answer relates only to the case under investigation or also involves some other matter. An answer to that will tend to incriminate him. So the point is this, whether it is confined to the case under investigation or it can extend to some other matter also. And their lordships have said it extends to whether it's a case under investigation or case not under investigation. If the answer to the question is going to incriminate him, he has a constitutional right to maintain silence. Now, how do you reconcile this with our Section 179 IPC? Section 179 IPC says that if you refuse to answer a question put to you by a police officer who is investigating, you are committing an offence. So the question is, at what stage the right of remaining silent starts? When you are formally accused, in the sense that your name is written in the FIR, or you are not formally accused. Their lordship says no. Whether you are formally accused or not is not relevant. As long as there is a reasonable apprehension that you may be accused, you have a right to maintain silence. The other aspect was that reconciling Section 179 read with 179 IPC, Section 161 CRPC and Article 20 Clause 3. Now there are a number of other propositions laid down in Nandini Saptapadi's case. It's those who practice in the criminal law should read that. This is a judgment which, because sometimes I'm sitting in the court and the prosecutor says he is not cooperating. And the court also says, you are not cooperating, we will not give you bail. There is a complete misconception. Where is his obligation to cooperate? What is his constitutional right recognized in Nandini Saptapadi's case? We have all forgotten Saptapadi's case. Or is it that Nandini Saptapadi's case available only to the powerful people? What is this argument? Every day I see that he is not cooperating. of course he is under no obligation to cooperate. It is the job of the prosecutor and the investigating agency to collect the evidence which is good enough to convict him. But this is now become a practical rule that the accused is not cooperating and therefore keep him in jail. Anyway, so the huge impact of Article 20 Clause 3 on criminal law, there are a number of other things. Maybe if you see my lecture on impact of constitution on criminal law, I have delivered 2 lectures I think here. There is a huge impact in several aspects. The one last judgment which I should mention on Supreme Court's interpretation of constitution on Article 21 with reference to criminal law is Basu's case, 97. Now Basu's case has also become a part of the statute. CRPC is amended. Which were the rights which were recognized in Basu's case? Number 1, that whenever a person is arrested, the officer who arrests him must carry a badge indicating his designation and his name, so that the accused knows who is this officer who is arresting him. Point 2, that he has the right to tell the officer that his relative or his friend should be informed about his arrest. Third, every district should publish a notice every fortnightly or 7 days, I forget, where the names of the persons who are arrested should be published, so that people come to know that so and so is arrested. So there is no question of secretly arresting him and taking him to some quiet corner of the world and put an end to his life. This will stop. Next, that if he says that he should be medically examined for any injury on his body, there is an obligation on the arresting officer to take him to a civic hospital, government hospital, for his medical examination. Now this is also extended to by Supreme Court judgment in the rape cases, etc. So this Basu's case has now become a part of statute. There are a number of now amendments in CRPC which are clearly a result of the Supreme Court judgment in Basu's case. Now this is the impact of Supreme Court's interpretation of Article 21 and other provisions of the Constitution on criminal law. We saw medical education. Now I go back to Article 12. We began with, there is a very interesting debate, and today in my opinion, the law is not in a very satisfactory state. Why do I say that? If you see the first 1950 judgment of the Supreme Court, a question arose whether a company, I am not talking of a government company, I am talking of a company, not a government company or not a state within the meaning of article, whether it has fundamental rights. Now, the first judgment which came in the case of that State Trading Corporation, which is 63 judgment, their lordships have said that a company is not a citizen. If you look at Article 14 and if you look at Article 21, they do not use the word citizen. They are the person. But 19 talks of citizen. So, freedom of speech, right to form association, 19(1)(c), right to move throughout the territory of India, etc., right to form an association, 19(1)(c). Now, suppose the right to carry on business under 19(1)(g), which is more important from the point of view of economic and business activities. Now 63 Supreme Court said that a company is not a citizen. Shareholders may be citizens, but the shareholders being citizens does not make company a citizen. So therefore your fundamental rights contained in Article 19 are not available to a company. And this law still, according to me, holds the field. But there have been some departures, and according to me, those departures have not crystallized into a form of a proposition that if the shareholders, substantial majority of the shareholders of a company are citizens of India, the company should also be considered as citizen. This is relevant from the point of view of restrictions on the right to carry on business. Very important. Some departure is made in Bennett Coleman's case, which is of Bennett Coleman came in 1972. The point is that periodically you will find, which we also saw with reference to putting more and more statutes in the 9th schedule. We saw that how Higher Kolo's case, and I also pointed out that this is inevitable. See, the doctrine of stare decisis can never operate in a society like ours where things are changing. So in Bennett Coleman's case, the Supreme Court has made a departure. Bennett Coleman is a famous company which publishes Times of India. Times of India. And the question was about newsprint allotment. And those were the days when there was newsprint was a scarce commodity. The paper itself was a scarce commodity. So there were serious restrictions on number of pages for which you can have a paper, etc., which came to be challenged as being arbitrary. Now in Bennett Coleman's case, some departure is made that a citizen's right of freedom of speech and expression 19(1)(a), because running a newspaper is directly related to 19(1)(a), also related to 19(1)(c), and incidentally also related to 19(1)(g). So for the first time, some departure is made from that 63 judgment of state trading corporations, where their lordships have recognized the rights of a shareholders being those of the company as well. But I don't take it that it's a full-fledged proposition. There are a number of riders. Now in this context, I put before you a very interesting proposition. Look at the arbitration law. We are slightly departing from constitutional law. But this has some nexus with the topic that we are discussing at present. And the nexus is this. If you see the last judgment in Cox and Kings, which was delivered, when was Cox and Kings delivered? I think some 2-3 months back?
Yes.
19?
22.
22, yeah. Now there was a debate going on with reference to arbitration law. A company which is not a party to arbitration, but it's a sister company or a part of a group of companies. So the group company theory is now well established both in company law as well as in arbitration law. It has yet to make its impact on constitutional law. From the standpoint of Article 19 or citizens' rights. Now, a chain of judgments where the courts have recognized the concept of a group company. They are so well connected, the management is more or less the same, they are in the same line of business, maybe A company does X, the B company does Y, and there is some kind of interdependence, integrality in their business operations, etc. Unified management, etc. Number of tests which the courts have laid down. Common office, common managerial staff, There are several such tests which the courts have got. And they have developed a known as a common common group company thesis. Then you have also the concept of an alter ego. That XYZ company is completely under the control of one single individual. Whether that single individual is an alter ego of the company. And if you see one of the judgments which is recently reported of the matter in which I appeared, I have sometimes I forget my names. Anyway, that Arun Upadhyay or whatever it is, it's a judgment of Justice Vikram Nath and Bhushan Gavai, where the principle of alter ego in arbitration was accepted. That one single individual was controlling the group of companies. And our contention that this other company, which is technically not a party to arbitration agreement, is there before the court through this person. And that proposition was accepted. And Cox and Kings is the basis. So the concept of alter ego group company is now established, firmly established as far as commercial law of this country is concerned. Why should this concept not then be extended? That's my question. According to me, lifting the corporate wealth proposition is now slowly entering into public law domain. It made its first impact in tax laws. If you see the Meenakshi Mill judgment, it's a way back old judgment, I forget the year. What year is that, Saloni?
1967.
1967, Meenakshi Mill judgment, where in order to find out whether there is a systematic tax evasion, whether the courts are entitled to lift the corporate wealth and find out who the person really is behind this corporate wealth. So in tax evasion matters, now it is settled that you can lift the corporate wealth. You can have the principle of alter ego. You can have the principle of group company. My question to me, the question which I ask myself is, why this principle then can't be extended? A slight departure was made in Bennett Coleman's case. Now it should be a full-fledged crystallized proposition that even for the purpose of other fundamental rights contained in Article 19, a company, if its substantial shareholders are citizens of India, why such a company should not be recognized as a citizen of this country. But as I said, the law is not crystallized. It is not in a satisfactory state. With that, I come to now a most volatile, sensitive. Last time I gave you a glimpse while closing my lecture, and that is about matters of religion. Now, I discussed with you the triple talaq case. But the triple talaq case is not the only matter where this question of what is an essential religious practice arises. This question arose way back in 1909 before Bombay High Court. I may be missing the year by one or two. In a case known as Jamshed versus Sonabai. Now the question was whether the Parsi Zoroastrian community, they follow a particular religious practice. Now who will decide whether that practice is an essential part of their religion? Whether a secular court or that community itself. The answer given by the Bombay High Court is in crystal clear terms that subject to public morality, etc. Whether a particular practice is an essential part of the religion or not is for that community to decide. Unfortunately, this line of judgments, which I am going to indicate to you, was not shown in triple talaq case. In any case, some references were made, but there is no full-scale debate. And last time I had pointed out to you that Justice Nariman and Justice Lalit, they proceed on constitutional morality, Article 14, etc. Justice Kurian Joseph, who takes the view that this is not an essential religious practice, and therefore it is bad in theology and therefore bad in law. The dissenting judgment of Justice K.R. and Justice Nazir is of no relevance as far as this aspect is concerned. Now there are a number of judgments which I just indicate to you which have substantially followed the principle laid down in Jamshed versus Sonabai. And according to me, this issue, because this issue will come with reference to Articles 25, 26, 29, 30, etc. Now, there are a number of these judgments which I will indicate to you where this Sonabai or the Jamshed versus Sonabai has been approved. And there is a long list. And I'll give you that list in a jiffy. Jamshed versus Sonabai is 1909, which I told you. Followed is Ratilal Panchalal Gandhi versus State of Bombay, 54. Bijoy Emmanuel versus State of Kerala, 1986. And there are a line of judgments which follow Jamshed versus Sonabai. So the question today is, which is now referred in Sabrimala. Now, Sabrimala, the first judgment said that this practice of stopping ladies of certain class from entering that sanctum sanctum of that temple is contrary to constitutional, contrary to 14. The question again involved here is whether what are the rights of a religious community vis-a-vis the other fundamental rights. Whether a particular religious practice is an essential religious practice or not, who has to decide? All these questions are now going to be debated again in Sabrimala case. But law as it stands today is that it is for that community to decide what is an essential religious practice, subject to secular laws, subject to public morality, etc. So when do I mean secular laws? Means the money that comes to, say, a temple or to a mosque or to a church, the state has a right to regulate it. Subject to these secular laws, secular aspects of these institutions are concerned, the state undoubtedly has a role to play. But religious practice, now this question is again now no longer concluded, it is now res integra. In the Sabrimala reference opens this issue. ये तो क्या कहते हैं, it's a trailer. बाकी है because constitutional law is, if I take up the field of education, we will require 10 lectures.
Yes.
Education field only. I have just given you a major landmarks, common entrance tests, the fee, etc.
Thank you very much,
Thank
sir. You covered Article 21 plus Chapter 4, TMFI judgment, education, capitation fee and everything, sir. Thank you very much. So nice. Give a huge claps to sir.